Hi there. Welcome to our sharing here on YouTube on the aspect of our legal education. And today I am very happy to share with you a subject matter on remedial law, procedural law under the concept of criminal procedure. And so therefore this will be a major discussion on criminal procedure, which I have called Speedy Criminal Justice. And it makes me feel comfortable to find out that while I have in the RTC of Mandaluyong a criminal case that has been dragging on for 10 years now without the prosecution finishing its laying of their evidences. When I went into this research, and while I'm familiar with the continuous trial circular of the Supreme Court, I was really very touched when the Supreme Court guideline provided that the period of trial from the first witness of the prosecution up to the end of the trial, it cannot exceed 180 days. And so that is about 6 months. And I don't understand, therefore, how a criminal case can last up to 10 years. And this is really already a violation of the fundamental constitutional principle of speedy justice. And so there are also other judges. I have another case right now here in Parañaque, RTC, where the prosecution presented its evidence, and yet it is very clear that they cannot prove the guilt of my client, the accused, on the basis of proof beyond reasonable doubt. So I filed a motion with leave of court, meaning with the permission of the judge, for a motion for the mirror to evidence. Again, my client called my attention. The judge is sleeping on our motion for the past 6 months. And so, again, these are very clear violations of the concept of speedy criminal justice. Our discussion today will zero in on the aspect of criminal procedure on the part of the prosecutor. And it starts with the assumption that the prosecutor is performing his duty on a on the basis of the presumption of regularity, in that he's competent, that he will not create a situation where his opponent can raise questions of motion to dismiss, precisely the mirror to evidence, for example, summary judgment or judgment on the pleadings. No, we will assume that the public prosecutor is efficient from the very beginning when the complaint affidavit is filed up to the time that judgment and entry of judgment is rendered by the trial court. And hopefully, we will be able to isolate the systematic flow of events under the concept of the prosecution doing the correct job. There will be a sequel to this where I will in turn label it as a strategic defense in criminal justice. And in that particular point, we will get the other side where you are now a defense lawyer trying to now study every component of the proceedings so that you can move for a dismissal of the case. So we will first tackle this discussion now on the aspect of prosecution, the prosecution side. Well, I in the past, I'm taking a little of your time introducing so much of my qualifications. Let me just cut it short. I come from three major areas. One is in my education. I am a CPA, summa cum laude. I have an MBA from UP, and that is Magna Cum Laude and Valedictorian. And my law degree is from the University of the East, Cum Laude and Valedictorian. I've worked for 45 years with the corporate world, working and moving up to the highest levels of financial management, working with good companies like GlaxoSmithKline, Fuji Xerox, where I was Executive Vice President, Chief Finance Officer, and Corporate Treasurer. I also worked with the electronics industry, Motorola Philippines, and I started my career with ESO Philippines that became Petron. I also had my stint with Meralco, its construction division, Philippine Engineering and Construction Corporation, with Delgado Brothers as the controller and director for management information and financial services. That's supposed to be in the transport industry, and I work with the agricultural chemical field, notably going around the Mindanao area in the banana plantations, pushing FMC's Furodan. And I had the chance to work with the World Bank on two projects, a project on fisheries and a project on the local water utilities administration. In the practice of law, I have had my luck in being nominated twice as Associate Justice of the Supreme Court. I do lecture with the Philippine Judicial Academy, the training arm of the Supreme Court. And I am the incumbent Dean, University of Manila College of Law. Its incumbent Vice President for Legal Affairs and a member of the Board of Trustees. I was also once upon a time a Dean of the University of Perpetual Help Colleges of Law of Las Piñas and Binyan. And I've been an MBA professor of LaSalle in financial management for 35 years, and at the same time bar reviewer and law professor in the University of the East, University of Santo Tomas, De La Salle University, University of Perpetual Help, San Sebastian, and Far Eastern University. To start the ball rolling on the topic of procedural or remedial law, let me again share with you a slide that came from another upload that is working student as a bar top-notcher. I had the opportunity to go through the 2019 bar examination on a per subject basis, grouping our schools by way of the top 4, San Beda, UP, Ateneo, UST, and then followed by the 11 leading schools that will now make the top 15 law schools that account for almost 60% of the passing mark for first takers. I also had a split between the Manila law schools with full-time students and working students, and finally rounding it up to Luzon, Visayas, and Mindanao. On this chart, you will see, for those of you who have not seen this before, are the heavy subjects in the morning, led by political law on the first Sunday, followed by civil law on the second Sunday, on the third Sunday is mercantile law, and on the fourth Sunday is remedial law or political law. The Supreme Court was kind enough to give the ratings of the number of students who passed on a per subject basis. And what is interesting here is that of the 4 heavy subjects in the morning, remedial law saw a real disaster in that out of an average of 10 students who took the bar examinations, only 2 of those who were fielded by San Beda, UP, Ateneo University passed. And the following leading 11 law schools has only 1 of them passing. Now, obviously, the Manila full-time law schools would have the San Beda, UP, Ateneo University candidates, and so that is the same 2 that is reflected here. But for the Manila working students, only 1 out of 10 passed remedial law, and that is also true for Luzon, Visayas, and Mindanao. I would no longer discuss the other subject matters because remedial law here has really been identified as a real bottleneck. And so if you try to evaluate what is causing our law students to fail in remedial law, it may be interesting to explore one hypothesis that I have. This is just to highlight the very poor performance of our bar candidates in remedial law. Almost no one passed. Most of them have only 1 out of 10 passing the subject on remedial law. And UP, San Beda, Ateneo, and UST have basically only 1 out of 5 of their candidates passing remedial law. There must be something terribly wrong with remedial law. And so I'm again extrapolating a slide that I made in that upload of Working Law Student as a bar top-notcher to discuss remedial law, where there is a need for a paradigm shift. There is a need to rethink how we're trying to understand remedial law. We said that remedial law is the set of procedures in the rules of court that the Philippine judicial system follows in order to enforce established legal rights by prescribing actions and imposing penalties upon those who violate said rights. It is the unique collection of procedures which litigation lawyers, prosecutors, judges, and justices adhere to in enforcing the rights being violated versus society in criminal law and or individuals in civil law. It is interesting to compare substantive law versus procedural law, and we say substantive law defines an individual's right which another person must recognize as his obligation to respect. And procedural law refers to the detailed steps in the judicial system to restore or compensate a person whose right was violated when an offender who failed to observe his obligation to respect that right. Procedural law is a system consisting of a start when a right is violated and it has an ending when said right is restored by a court judgment or order. Procedural law is understood and adhered to when the steps from the start are laid down systematically towards the end to reflect how the violated right is restored or how the person whose right was violated reacquires and are compensated for his deprived right. Philippine procedural law, my dear friends, embodied mainly in the rules of court, can stand major improvements in laying down, in a simple but systematic flow, the trial steps to achieve speed and efficiency. The rules of court needs to be rewritten along the process flow structure with a clear start and a decisive ending. Evidences, that is testimonial, object, and documentary evidences, are to be clearly shown in the process flow so there is assurance of easy and clear compliance. And the constant court squabbles among legal and presiding judge may be symptomatic that the procedural rules can indeed be confusing. The poor performance in remedial law of the bar candidates may be indicative that what is being taught may not really be fine-tuned to a speedy and systematic flowing judicial process, albeit recent amendments to the rules. And so, in the following slides, we try to precisely put on the table an attempt to rewrite, at least in PowerPoint process flow structure, the start and ending of criminal procedure. And our objective is, number one, to allow our law students, especially those who just graduated and those who are graduating, to take the 2021 bar examination, to have a stronghold of precisely what criminal procedure is all about and what they need to understand by way of a process flow of criminal procedure. To start the ball rolling on speedy criminal justice. The slide is moving along the lines where you have here the so-called play script method, where you list down the steps as they come in the logical flow, and you identify who is the party involved and what action does it take. This particular play script method is dovetailed with the process flow diagram at the upper portion of this particular slide. For example, you have here an offended victim being carried, hopefully for his safe condition, to the hospital. And so, being an offended victim, the question is asked, will he ask for police assistance? And so that was also what is written here in our written procedure. The offended party is the first step. He would ask for police assistance on a crime violating his right. And if the answer is yes, therefore, the police officer, the PNP police, comes into the picture. And so the police assistance is sought by the victim, and the police officer asks, arrest the suspect with no warrant. And so that particular answer is answered by our rules of court and also under criminal law. And so we go to step number 2 by the PNP police officer. And so he is now encouraged to follow the procedure of either arresting the suspect, or if he, normally a police officer is very smart, if he is doing a warrantless arrest, he plays it safe by saying, sir, can we invite you for a little, investigation? And so that essentially addresses the possibility that the police officer may be sued for unlawful arrest when he is invited. Because if the suspect adheres to going with the PNP police officer, it cannot qualify as an unlawful arrest because the officer did not arrest him but simply invited him. Very smart move on the part of our police force. So that is not a violation of any right whatsoever. However, just granting for the sake of argument that the police officer in fact invoke the provisions of the law on warrantless arrest under Section 5, Rule 113 of the Revised Rules on Criminal Procedure. What are these instances when the police officer can undertake a warrantless arrest? The first one is when, in the presence of the arresting officer, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. So this may be an immediate past, a current happening, or an attempt to commit an offense. And so it is done in the presence himself of the arresting officer, and that is acceptable under the rules on warrantless arrest. The second instance where warrantless arrest is recognized is when an offense has in fact just been committed, and the arresting officer has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. In this particular case, the offense has already been committed, and the arresting officer just came in within reasonable time when the offense was committed. And based on his personal knowledge, this arresting officer is convinced that there is probable cause for the accused to have committed the offense. So the difference between 1 and 2 is that in 1, actually there is an actual physical presence of the policeman right there on the scene of the crime, just immediately before, during, or after the crime was committed. In the second case, the policeman was not yet there but came in just a little after the offense has been committed, And based on his personal observation, like for example, he saw a dead person right there bleeding, and there is a person beside it still holding the knife that is with tainted blood, and everybody is pointing to the supposed assailant as the accused. Well, on the basis of his personal observation, it would appear like the police officer can also undertake a warrantless arrest. Of course, number three is the easiest, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporary confinement while his case is pending, or has escaped while being transferred from one confinement to another. So the most important thing here would be in the physical presence of the arresting officer. Second, when there is probable cause on the basis of the arresting officer, based on his personal knowledge that the offense has been committed and the suspect is the one who could have committed the offense. Moving now, we will take a look at how this whole thing will proceed. And so the question now is, if the arresting officer, what would the arresting officer do with the suspect that was arrested under warrantless arrest? We expect, of course, that the victim will make a statement and finally sign an affidavit, which is the complaint affidavit. And this therefore leads our arresting police officer to conduct a custodial investigation. And this custodial investigation would be influenced by two major documents. The victim's complaint affidavit, and the investigation data form that the police officer can accomplish as an outcome of the custodial investigation. And with the complaint affidavit and the investigation data form, the prosecutor now would have the opportunity to conduct an inquest of the crime incident. And the inquest obviously will be coming from the custodial investigation. But coming back to the police investigator conducting the custodial investigation, at the time that the suspect is already under the custody in the police station, the investigating police officer tells the suspect of his right versus self-incrimination, that he has the right to remain silent, that anything that he may say can be used against him in a court of law, and that he is entitled to a lawyer of his own choice. That is the reiteration of the mention or disclosure or advice to the suspect under custodial investigation of what has been known as the Miranda Doctrine. The next is the police investigator now prepares the investigation data form, and it has a very structured format that normally in the whole Philippines now, the Department of Justice and their prosecutors appreciate that investigation data form to be filled up by the police investigating police officer or even by the complainant, that will be submitted for purposes of inquest or preliminary investigation. And so the police officer now prepares the investigation data form with the medical results and other evidences lawfully taken from the crime scene and the custodial investigation. Obviously, this is now bound to be brought before the public prosecutor. And so the police investigator brings the suspect before the prosecutor for inquest proceedings, submits to the public prosecutor the available offended party's complaint affidavit, any suspect's counter affidavit, the police investigation report, which is essentially the investigation data form, the suspect's medical report, and all available documentary and object evidence will be now presented to the prosecutor. And on the advance side, the judge on duty under the present quarantine guideline, there is now a judge on duty on standby rather than being the case being raffled immediately. There is now a judge on duty who handles all of these duties. And so the complaint affidavit prepared by the victim now goes with the police investigation data form, both being submitted now to the public prosecutor, so that the complaint affidavit and the investigation data form, together with all the available evidences, documentary, even testimonial evidences by the frame of affidavits, and finally object evidences, would be submitted to the prosecutor for purposes of inquest. It is very important for us to call attention that the inquest happens because the suspect has been arrested without any warrant at all, so that the inquest proceedings can now proceed. And continuing now with the inquest proceedings, the fiscal now, looking into the complaint affidavit and also any counter affidavits and the investigation data form, would now be able to toss the question on whether or not there is probable cause. Probable cause that the suspect must have committed the offense and that the offense in fact did happen. And if he decides that there is probable cause, then he prepares a resolution, submits that with the approval of his chief city prosecutor, and therefore proceeds to submit his information to the judge. So that the sequence of events, there is a warrantless arrest, there is custodial investigation, there is a complaint affidavit from the victim. The custodial investigation can trigger an investigation data form. All of this together with all other available evidences goes to the public prosecutor, who makes an informal inquiry in order to determine whether there is probable cause to bring the suspect into trial. And if in his evaluation there is, then he prepares a resolution, secures the approval of his superiors in the Department of Justice, and finally forwards all this information plus the resolution and all other evidences to the judge on duty. And so when we see now the whole situation now before the judge on duty, with the resolution and information in his hands, the judge now proceeding with reviewing whether there is probable cause based on his own evaluation and independent of the prosecutor, and if in his evaluation there is probable cause, he now issues a commitment order when the suspect is already under arrest within 10 days from information when he finds probable cause. So the public prosecutor prepares the information with the resolution, secures the approval of his superiors in the Department of Justice, and all of these are submitted so that to the judge, who in turn can issue a commitment order 10 days from the time he received the information to in effect hold the suspect and not release him if there is probable cause. And so a commitment order is issued that will now authorize the arresting officers, the PNP, to continue to hold the suspect in incarceration without violating Article 125 of the Revised Penal Code on the number of hours that the police officer can necessarily hold the suspect in custody. For light offenses, it is 12 hours. For afflictive offenses, for correctional offenses, it is 24 hours. And for afflictive offenses, starting with presyon correctional in the medium term of 4 years, 6 months, and 1 day, all of this now, therefore, would allow a commitment order to be issued so that this particular person can now be held without violating what we just mentioned a while ago as the holding hour or hold time for a suspect who was arrested without any warrant of arrest. Continuing now, the victim, who is the offended party, can now undertake 2 steps. Number 10, the victim can now file a complaint, a sworn written statement charging a person with an offense, subscribed by him for preliminary investigation. The difference within this is that it is the same complaint, but if the suspect was arrested without any warrant, the complaint needs to be immediately done. However, if the suspect cannot be arrested under the warrantless arrest, then to trigger his prosecution, the victim and offended party can prepare a complaint affidavit together with a draft of the investigation data form to be submitted directly to the public prosecutor. It does not pass through the police officer anymore. This is what is popularly known in the practice of law as direct filing of the case. And so the direct filing of the case by the offended party can either be done on 4 alternative recipients. Number 1, provincial, city prosecutors and their assistants. Second, judges, municipal trial and circuit trial courts can receive the complaint. Third, national and regional state prosecutors. Number 4, other officers authorized by law. Now, when the victim therefore submits the complaint affidavit, he should make sure that the complaint is sufficient by ensuring that his complaint has the victim's name, that is him, the accused name, which is the suspect, the designation of the offense, and the act or omission complained of as constituting the offense, the date of the offense, and the place of the offense. So those are the minimum requirements for a complaint to be filed by a victim or offended party before the public prosecutor. The public prosecutor in turn, as he gets these documents, will now undertake to prosecute the criminal action based on the complaint or information. It is the prosecutor, public prosecutor, that is given the task to prosecute a criminal action. The public prosecutor undertakes the preliminary investigation to determine whether there is sufficient ground to engender a well-founded belief that a crime is being committed and the respondent is probably guilty thereof and should be held for trial. And so on the basis of this preliminary investigation, the preliminary investigation, by the way, required for an offense with the penalty of presyon correctional in the medium term, 4 years, 2 months, and 1 day or more, and not when the penalty is less or the suspect is arrested with no warrant. So that is when a preliminary investigation can be conducted by the prosecutor. Otherwise, especially when there is a warrantless arrest, instead of preliminary investigation, it goes into inquest proceedings. Now, when the public prosecutor now therefore evaluates and finds preliminary uh, probable cause, he now subpoenas the suspect within 10 days when the complaint was filed. And that subpoena now is served on the suspect, who in turn can submit his counter affidavit and document for defense within 10 days from the subpoena. So there you go. And once the public prosecutor receives, he has already the complaint affidavit, he has the data, investigation data form, he now receives the counter affidavit of the suspect, he weighs the arguments for and against, including the evidences, to determine whether there is probable cause. And continuing now, the public prosecutor can even set a hearing to clarify facts and issues within 10 days from counter affidavit. So the suspect submits a counter affidavit and therefore creates a certain gray area or conflicting versions of the offense. And to clarify that, the public prosecutor has 10 days from the receipt of the counter affidavit to call a hearing. And after the hearing, finally, the public prosecutor prepares a resolution and information when he finds probable cause for the respondent for 10 days from hearing investigation. This particular resolution now and is submitted to the judge on duty, and the judge on duty evaluates the resolution and its supporting evidence to find likewise probable cause to issue a warrant of arrest within 30 days from the filing of the complaint. So there you have it. You have probable cause, and you therefore serve the warrant of arrest on the suspect so that the suspect now can be arrested by the PNP because he could not be arrested under warrantless arrest at the start of the case. The arresting officer takes a person into custody, restraining him to answer for an offense, delivering him to the nearest police station or jail within 10 days from warrant. The accused now would wish to be freed temporarily, and so he posts bail as a security given to release him from legal custody to guarantee his appearance before the court. That is the purpose of the bail. It's a security to ensure that the suspect can be released, but he will appear in court when his arraignment comes up. The judge on duty grants bail as a matter of right and releases accused in custody. And therefore, by going to court and by the court finding him, and the court now grants bail, therefore the court has assumed jurisdiction over the suspect. And so the next step will be for the judge on duty to arraign the accused within 30 days from acquiring jurisdiction or bail with the reading of the information, and asks the accused whether he pleads guilty or not guilty. On the part of the accused should be personally present and enters his plea of not guilty or guilty. The judge on duty now will order a pre-trial conference after within 30 days after arraignment. So the arraignment is already done. And so In the case of orders, the judge ordering a pretrial conference within 30 days after arraignment, the pretrial conference is called for in order to allow four possible or six possible legal effect. Number one is for plea bargaining, that the accused may offer to surrender himself or to admit an offense lower in rank and penalty than what is being charged of him. There will also be stipulation of facts, that there are certain facts that the both parties will agree not anymore to dispute. Any evidences, both documentary, for example, and object evidences, can now be marked as Exhibit A, Exhibit B, the alpha indications for the prosecution, and the numeric numbers of Exhibit 1, 2, 3, 4 for the defense. And here, there may also be an issue on whether any party will waive any objection to the evidence presented. Now, if this is a crime against persons and the suspect or the accused invokes self-defense, then the pretrial conference will now ascertain how to conduct now a reverse trial, where it will be the defense that will present first its evidence in order to establish that he has the benefit of a self-defense. And the pretrial will have other factors such as to ensure that there is fair and expeditious trial. The pretrial conference leads to a pretrial agreement, and the judge therefore issues a pretrial order to become the controlling document in the conduct of the trial. There is the pretrial conference and the pretrial order, and the pretrial order now is served on the prosecutor as well as the accused. And we therefore are ready to proceed to trial. Let us now go to the next slide. And of course, the trial will lead to judgment. In the next slide, we focus now on the proceedings before the court on the right side of our slide, while the left side will handle the play script listing. Proceeding now with step 28. The prosecutor now starts the continuous trial within 30 days from the pre-trial order to be completed within 180 days. Very critical. The continuous trial should be finished, both prosecution and defense, within 180 days. And so the prosecution now presents the evidence for the prosecution, the witness testimony, the documentary evidences, and object evidences in order to prove the criminal and civil liabilities subject to defense's cross-examination. After the prosecutor, after the prosecutor is done with the presentation of the prosecution evidence, then the accused will now be given his day in court. The accused also presents his evidence, witness testimony, documentary evidence or evidences, and the object evidences to prove his defense and damages subject to prosecution's cross-examination. After the first round, the prosecutor and the accused, the counsel for the accused, would have the opportunity for the prosecutor to present rebuttal evidence and for the accused to present a sur rebuttal evidence. Moving now to the judge. In step 33, the judge admits prosecution and defense evidences to deem the case submitted for decision within 180 days trial. The judge promulgates judgment personally and in writing to judge that the accused is guilty or not guilty, with facts and the basis in law of the offense charged, the penalty and civil liability, reading it in court with the presence of the accused. There is the accused presenting his defense evidence, and there is the continuous trial moving to judgment. The judge now therefore formulates judgment personally in writing to judge that the accused is guilty or not guilty, we said that, with facts and the basis in law of the offense charged, the penalty and the civil liability, reading it in court with the presence of the accused. Now, what is important is that in the decision, in the judgment, which is read in the promulgation, the acts which qualifies the offense committed with the aggravating or mitigating circumstances would be recited. Second, the accused participation as principal, accomplice, or accessory is likewise handed down. And the penalty imposed on the accused and the civil liability for damages. And finally, after the promulgation of sentence, there will be an entry of final judgment to ensure the execution of the penalty as discussed. And so there you are, ladies and gentlemen. We have attempted to simplify the flow of procedures in remedial law, particularly in the revised rules on criminal procedure. We venture to call this speedy criminal justice because when the procedural flow is made clear, the way we tried it, then we feel that this will accelerate the trial process and would allow us to have justice no longer delayed. And so justice will no longer be denied. And we hope that this kind of exercise will allow not only the law professors, the law students, practicing lawyers, as well as presiding judges, but also the ordinary layman of the street to understand what happens when his relative or himself enters now a difficult stage where he becomes a party, either a complaining, offended victim, or the suspect or the accused in a criminal offense. Let us hope that this particular presentation will allow us to appreciate the criminal procedure in our courts of justice.